I won't take long, Malas.
Yes.
Deeply obliged. No intention to cover your lordships too much, Malas. Malas, just, Malas, the 10th schedule was incorporated in the Constitution in 1985. 179 has been there before, Malas.
Yes.
So, Malas, well, there was no 10th schedule, yet you can ask for the removal of the speaker. For reasons that have nothing to do with the 10th schedule. So, first question, if you seek a removal of the speaker, which has nothing to do with the 10th schedule, is he barred from dealing with disqualifications? Makes no sense. We are arguing as if the only reason for removal is the 10th schedule. There are any number of reasons for which a speaker can be removed. So he'll be debarred to perform his adjudicatory function. Ex facie, a wrong proposition of law. Ex facie. In fact, Maharaj, 179 operates in an entirely different field. That's why the 10th schedule uses the word disqualification and 179 uses the word removal.
So if the Nabam principle is right, then once a notice is given of an intent to move a resolution to the speaker, not on the 10th schedule, but for any other reason, so long as the motion is pending.
That's right, the motion is pending. How does that, how will this argument be? You will then have to make a distinction under 179 itself in interpreting 179 read with the 10th schedule?
No, but logically, Mr. Sibal, the argument of the principle in Nabam will extend irrespective of what the cause for the...
I agree, but that's what I'm arguing about.
That's right.
That's precisely what I'm arguing.
Because once the principle which Justice Mishra seems to have laid down is that once, and Justice Kher also, that once a notice for your removal is given, then, you know, then there is a...
But there is a
except for one thing, I'll tell you what.
Yes.
In case of the 10th schedule, there's one additional factor. That when the speaker acts to disqualify somebody under the 10th schedule, he is affecting the majority in the electoral college, which will decide upon his removal. Right?
Correct, but that's fine.
Suppose a speaker is supposed to be sought to be removed on the ground that, well, for whatever behavior in the house. They say that, well, you have not given the opposition sufficient time to speak, or you have not been even-handed. Just hypothetical.
Correct.
In that case, there is no conflict of interest as such. That conflict of interest is taken care of by 181. Namely, that on that day when the motion comes up for consideration, you will not preside. You will have a right to vote.
That is motion to remove him.
Motion to remove him.
Absolutely right.
But there's no question of the speaker affecting by excluding certain members of the legislature.
I agree.
Because here what happens is the moment you rule on the disqualification, you are affecting the balance or composition of that body which will vote on.
I agree entirely with your lordship. Therefore, but 179 will still have to be interpreted in any situation. You can't ultimately you'll have to say that 179 in this context will not operate.
No, that you see the Constitution lays down the principle in regard to the overall conflict of interest in 181. Irrespective of whether it's on the 10th schedule or otherwise.
I am saying that.
But on the 10th schedule disqualification, our court has introduced an additional...
but that's the problem. That is the problem of the case.
But your argument, Mr. Sibal, your argument that the same principle will apply to any motion for removal may not strictly be right.
But Malad, the Nabam Rabia doesn't say so. Your lordships may interpret Nabam Rabia like that. But Nabam Rabia doesn't say so, Malad. We are now saying you will have to clarify it. You clarify it by referring to 7. I'm on the principle, Malad. I'm not arguing the merits here. I'm on the principle. Nabam Rabia doesn't make that distinction. Your lordships may wish to make it. That's another issue. Malad, let me just move. This is one issue. Number 2. But in fact, 179 was incorporated in the Constitution for the removal of the speaker because removal involves a stigma for cause. And therefore, you will see in the constitutional provisions his right to participate in the House and defend himself. It was nothing to do with the 10th schedule. You see the provisions 179, 181. He will, at the time when the motion is moved to remove him, he'll preside over the House.
Actually, you're right. 179 and 181 have nothing to do with the 10th schedule.
Exactly.
Because that's why when the 10th schedule came in by the 50th constitutional amendment,
Yes.
they recognized that in 191.2 and 102.2.
That's right.
But they didn't amend the provisions of 180, 179.
That's correct. That's correct.
They left it intact. What's the reason? Parliament left it intact.
There's a reason why they left it intact. See the proviso. See the proviso to paragraph 6 of the 10th schedule.